Hi, and welcome to Chapter 2 of my course on intellectual property and trademarks. Whether you are starting a new business or just growing your brand, or just simply curious about how to protect what makes your brand unique, you've come to the right place. My name is Omar, and I've spent a decade helping businesses safeguard their identity and avoid costly mistakes. Today, we'll talk about trademarks. What are they? Why are they essential? And how do they work? We'll start with the definition of trademarks. What is a trademark? I'll give you a general definition and then we'll go towards the Trademark Act of 1994 for the legal definition and explanation of all the legal sections. In this landscape of intellectual property, a trademark is just more than a name or a logo. It is a vital asset that distinguishes goods and services from one provider to another. A trademark can help consumer identify the source of the product or the services, which in turn fosters trust and brand loyalty, which are very essential in today's market. It's a very competitive market. Just to give you a historical context, one of the oldest registered trademark was registered in 1876, and it is widely recognized as the red triangle symbol of Bass Brewery Company. It holds the distinction of being the very first trademark that was registered in 1876. And the story goes that one of the representative from the Bass Brewery Company waited outside the registration office on the New Year Eve to ensure that they were the first one to register a trademark under the new law. This red triangle is very iconic, and it is still recognized as the earliest example of brand protection. Trademark law generally originated in the late 19th century as commerce and businesses expanded globally. That created a need to protect brands from competitors and counterfeiters. So, for example, Coca-Cola's iconic logo was trademarked in 1893, yes, which gave them protection against intimators, and over time, the Coca-Cola company added more trademark protections to their portfolio. And just to give you an example how trademark law has evolved, so the MGM Lion Roar and the sound mark was registered in the later period when you will see that as the industry expanded, more things needed to be protected. So the law evolved to make do for more kind of trademarks to be incorporated for protection. If we see the Trademark Act of 1994 of United Kingdom, the legal definition of a trademark would be under Section 1, Section 1.1, A and B. So Section 1.1a, what does it say? It says a trademark means a sign which is capable of being represented in the registrar in a manner which enables the registrar and the other competent authorities and the public to determine the clear and precise subject matter of protection afforded to the proprietor. What does this mean? In simple terms, it means that your trademark must be clearly defined so that the authorities, the registrar, and the public can understand what is it exactly what is being protected. So, for instance, from a famous example, Adidas logo, the 3 parallel stripes, is distinctive and recognizable, and it shows clearly what is being protected. So if we, for an example, if I will create a word mark. So, for example, if we want to register spirit sound, it's two words, very clearly, two dictionary elements joined in together. Spirit sound. So what it means is that if we want to have this as our mark, for instance, what we would do, we would go to the registrar, which will be able to register this. So if you see, it is clearly, we are very clear in defining what is being protected. We want the protection for a word mark, which is two words, spirit, sound. Other people, the competitors and the public, would be able to know that as well, because we are clearly defining our registration. If we come to the Section 2 of the Trademark Act, Section 1B, So that says a trademark, what it means is it should be able to distinguish goods or services from one undertaking from those of the other undertaking, and I expand, a trademark may in particular consist of words, including personal names, design, letters, numerals, color, sound, or the shape of the goods or their packaging. What it means in simple terms is a trademark is crucial tool for distinguishing your goods and services from those of the competitors. So it kind of serves as a unique identifier, allowing customers to recognize that product or services, which would mean that it originated from your business rather than somebody else's business. And this differentiation is very vital in building the brand loyalty and trust as a consumer. So taking the same example, for example, spirit sound, what we have kind of done is, if we give it goods and services, let's just say coffee beans, coffee filters. So now what we are doing the register is that first we have a word mark that we want to protect, and then we'll give them the goods and services that we want it to be protected on. That would be coffee beans and coffee filters. So that is kind of distinguishing the goods and services. So we are telling the registrar what we need the protection for, then telling the goods and services that will distinguish us from the other people, other businesses. And what it says, the Section 1B, is that it can include words, designs, logos, numerals, colors, sounds. So think of a very known logo or a distinctive product design that immediately identifies a brand. For example, an Apple logo or the Nike swoosh. This is instantly recognizable, and it just reinforces the brand identity and builds trust. That is what we are looking. So what the trademark is doing is protecting the consumers and yourself, so that the consumers know where the product is coming from. And if the business has built up a goodwill over the years, a trust among the consumers, they would be able to capitalize on that, that trust that they have built. So if we see the second, for example, if we see the second section, which the second section is not very important in terms of, I mean, it is very important, but in terms of this course, we wouldn't go into Section 2. That this basically says that the person who registered the trademark has lots of rights in that. So I'll just go through the second section. So no proceeding lies to prevent or recover damages from the infringement of an unregistered trademark as such, but nothing in this act affects the law relating to passing on. Simply put, if a trademark isn't officially registered, the owner can't sue for infringement just because someone else is using it. However, the law still offers some protection through the concept of passing off. And you may ask, what is passing off? Passing off means that if somebody else uses an unregistered trademark in a way that misleads the customers or damages the reputation of the original business, then the owner can take legal action to stop it. These rules protect businesses from unfair competition, and even without registration, for instance. Now we come to Section 3 of the Trademark Act, absolute ground for refusal. So there are, law clearly states what are the grounds for refusing the registration of a trademark. And it comes under Section 3. So bear with me, it's a long list. We'll go through it together. I'll explain slowly how the Section 3 of the Trademark Act works. Absolute grounds for refusal. Certain trademarks may be refused a registration if they fail to meet certain criteria that are set by the laws. So Section 3(1)(a) says, for example, signs which do not satisfy the requirement of Section 1. Simple explanation, if the sign does not make the basic requirements laid out in Section 1, first being clear and distinctive, right, it won't qualify for registration. For example, a blurry logo or an unclear symbol, that wouldn't meet the requirements since it would be difficult to identify what is it that is being protected. Section 3(1)(b) of the Trademark Act states a trademark which is devoid of any distinct character. So that means marks that lack distinctive qualities, meaning they don't stand out, so they cannot be registered. So for example, if we say clean and fresh as a trademark for soap, it's generic, it doesn't differentiate the brand. In contrast, for example, Lush is a distinctive and easily identified product for bath products. Is distinctive and easily identifiable for its bath products. If we say, if we take a real life example in Apple Corporation Inc. versus the Office of Harmonization, Apple had to prove that the consumer associated the word Apple with technology products, showing that even common words can gain distinction through the use of that mark. Then we will come to Section 3(1)(c), which states trademark which consists exclusively of signs or indication which may serve to designate the kind, quality, quantity, intended purpose, value, geographical origin, the time of the production of the goods or the rendering of the services, or any other characteristics of the goods and services. What does this mean? This section basically says that this prevents generic or descriptive terms from being trademarked. For example, New York pizza for a pizza company is too descriptive, while Domino's, for instance, is very unique. The purpose of this rule is to ensure that the brand can not monopolize everyday life. So just think of it, if you register clean and fresh for your soap, it's not very distinctive, right? So if we get an example of like New York pizza, if you're opening up a pizza shop in New York, it's not very distinct, right? It has to be unique. It has to be identifiable. And for instance, if somebody has a New York pizza registered under them, then the competitors wouldn't be able to put them in their brochures. Oh, the best pizza in New York. Or you wouldn't be able to tell the customers where the product becomes more originates from your business, and then it might just create confusion. And that's what the purpose of the trademark law is, not to create confusion among consumers. So if we go to section 3(1)(d), which says trademark which consist exclusively of signs or indication which have become customary in the current language or in the bona fide and established practices of the trade. What does it mean? It means a mark composed only of the words or signs commonly used in the industry. It won't be registered. So, for example, ice cream shop for an ice cream vendor is too generic. However, if the generic phrase becomes distinctive due to excessive use, it may still qualify for registration, like Windows for Microsoft operating system. Section 3(2), shapes and function provision. So section 3(2)(a) says the shape which results from the nature of the product themselves. It means a trademark cannot be the natural shape of a product. So for example, you can't trademark the basic shape of the loaf of bread, since typically all the breads are the shape of breads. They're bread, and that's just the nature of the bread. So you can't register that shape, because if you register that shape, nobody else would be able to register. Is anybody who creates bread would be infringing on it. So the law allows that provision to not trademark something that is natural in this of the product. Section 3(2)(b) says the shape of goods which is necessary to obtain a technical result. So functioning shape are necessary for the product to work properly. A screwdriver is a good example. A screwdriver handle shape, it cannot be trademarked because it is the function of that product. Make sense? So if you are trying to register a trademark for the screw handle of the screw, it wouldn't be possible under the law. Section 3(2)(c), the shape which gives substantial value to the goods. It means if the shape or the appearance of the product greatly adds to the appeal or value, so it also cannot be trademarked. For instance, the distinct shape of Coca-Cola bottle was originally trademarked for its unique design, but not for the bottle's utility. So let's just say a soap bar. If it's a square, you cannot register a square soap bar because that is the functional shape of it. You can have a different shape soap bar and then you can put in an argument that it is unique. But generally, you wouldn't be able to register a shape which gives substantial value to the goods. There are different requirements in different parts of the world. So different countries have their own requirements for trademark registration. So for example, United States often requires a proof of secondary meaning when claiming color trademarks, where applicant must prove that the public association of the color with their brand. The Madrid system under the World Intellectual Property Organization requires that some marks, for example, like those involving colors or sound, must also have a graphical representation in certain cases. So the common pitfalls that we find among our customers, when I deal with customers, they sometimes come up with a very generic element. So Fresh Juice Corporation. And when you ask what are they producing, they will say fresh juices. We wouldn't be able to register that. But if they come with a new name, for instance, Tropicana, then there is no description and it's easier to protect that brand. Even in the terms of the example that we were taking, spirit sound, coffee beans, and mugs, coming up with saying great coffee company, we wouldn't be able to provide because it's not very distinctive. But spirit sound is very distinctive. So we can add that. I would advise that it's a good tip to naming your company would be to have a little uniqueness, right? So to improve distinction, consider combining words with visual elements, using unique fonts, or even incorporating a non-traditional element like color or sound if it's allowed. So for example, Burberry adds value with its signature plaque design, which is trademarked and enhances its brand recognition. Similarly, Guinness has multiple trademarks that it protects. So the key takeaway from this chapter would be absolute ground for refusal. For example, this we explored the essential requirements for trademark approval, including distinctive, non-misleading use and protection from generic terms. Then we have to look at the section 1 we discussed, in which we clearly defined how should the trademark be presented. So clear and precise manner. The distinction of goods and services from yours to another. That's the second part. And just avoid any descriptive or generic names. Enhance the trademark name that you're selecting to a more unique name that would help consumers on the long run identify your product. And if you're able to create trust among your consumers, they will recognize your brand and they would want to come back to purchase the same thing. The whole purpose of the trademark is to protect what's yours so that other people cannot take advantage of your success. If you think that we start a coffee bean company, right? So we would not want anybody to take advantage of our success. If the coffee company starts to sell those spirit sounds, starts to sell a lot, and we would want that protection under the law so that nobody else can come and steal our name or have a similar name, just so that people start to associate their name with our name. And that's the distinguishing feature, what the trademark provides. It gives consumers the confidence and the protection so that they can make repeat purchases, knowing that the originator or where the products have originally come from. So if you see, for example, if the coffee company that we gave an example of, if we would spend money on marketing, we would spend money on the shop, there would be a huge capital put into. And if somebody else comes in and just tries to steal that or try to imitate that, it would hurt our brand. If the competitor is selling a cheaper version of coffee, people would not come back to us if they are confused from the origination of the product. I know it's a lot to take on, but the whole process of trademark registration is to provide the businesses a solid protection against any imitation or somebody trying to take it. In the next chapter, we will see the subject matters of what can be protected. What is it that we can protect under the Trademark Act of 1994 from UK? Until then, I hope you have a lovely week, a day, in a month. Adios.